Morning. Oh, hey, you're back. Today's video is on preparing the pleading portion of the plaintiff's claim. Right off the starting line, there are 7 rules that you need to follow when preparing your pleadings. Rule number 1, use headings. Headings break up your pleading and allow for easy reference. Rule number 2, always make sure your pleadings are double-spaced. Not single-spaced, not spacing and a half, but double-spaced. Double spacing allows a judge to read your pleadings quickly and efficiently. Rule number 3, always use 1-inch margins. You don't want your sentences to start at one edge of the page and go to the other edge of the page. It's just not professional. Rule number 4, use 12-pitch print. Most judges are my age or older, and I can tell you that as you reach your 50s, your eyesight's not going to be getting any better. The worst thing is to have a judge try to read your pleadings while squinting. It's just not something that you want to put the judge through. Always make sure that you use 12-pitch print. Number 5, consecutively numbered short paragraphs. Now, the emphasis here is on short paragraphs. 1 point per paragraph. No run-on sentences, no lengthy paragraphs. Simply 1 point per paragraph. Rule number 6, always use proper bindings. The standard form of a plaintiff's claim encourages us to attach documents upon which we're going to rely. If you're going to be attaching a fair number of documents to your plaintiff's claim, always make sure that your plaintiff's claim is properly bound and tabbed. This is a properly bound and tabbed court document. You'll notice that the documents each have their own tab. On the other hand, this is not a properly bound document. You might get away with this in high school, but not in court. This is a very difficult document when it comes to fitting it into the court file. It's just not professional. It's not something that you want to use in court. Finally, rule number 7, always number your pages. Not just the pages of your pleading, but you have to continue to number your pages all the way through from beginning to end. Make sure that all the page numbers of the standard form are numbered, all the page numbers of your pleadings are numbered, and all of the documents on which you rely are also page numbered, and it should all be consecutive. You don't want to be in front of a judge at a settlement conference or a motion or at trial and say, "Your Honor, if I could have you count in 10 pages from..." No. What you want to be able to do is you want to be able to stand in front of the judge and say, "Your Honor, if I could refer you to page 22 of the plaintiff's claim." Or, "Your Honor, if I could refer you to tab G, page 22 of the plaintiff's claim." So, with that in mind, let's get going and get that pleading done. Let's take a look at the pleading. I like to provide a title to my pleadings. In this case, it's scheduled to plaintiff's claim. Now, the first thing I'd like to do is to take a look at the rules that we covered earlier. You can see that I've used various headings in order to break the pleading up for easier reference. In this case, we have headings such as the claim, the parties, products and supplies, the personal guarantee, and the judgment requested. You'll also notice that the entire pleading is double-spaced so that it's easily and quickly read. It has proper margins, 1-inch margins. You can also see that it's done in 12 pitch and that there are consecutively numbered paragraphs. Now, if we were going to attach documents, we would number those documents beginning with page number 6. You can see that the 2 pages here are pages numbers 4 and 5, and the reason why it begins with 4 is because our standard form ends with page 3. Now, what I like to do when preparing the pleading is I like to follow the Superior Court format. You can see here that paragraph 1 simply is the amount of the damages, how interest is to be calculated, the basis for claiming costs, and of course we always put in this last item here, such further and other relief as this honorable court deems just. Now, some of this is already covered in the standard form, but that's okay. I like to do it this way because it looks professional. Now, after that first paragraph, the claim, what I like to do is introduce the parties to the action. So you can see here that paragraphs 2, 3, and 4 introduce our client, Superior. They also introduce the 2 defendants, Jolly Good, which is the corporation, and Joseph Jolly, the individual behind the corporation who signed the personal guarantee. After introducing the parties, I like to get into the gist of the matter. You might remember that in the video having to do with the client interview, I suggested that you approach things from the point of view of a date, an event, and the evidence in support of that date and event. Now, if at all possible, what you should do is you should follow the same format when drafting your pleading. So you can see in paragraph 5, I've started out with a date or a range of dates. I've then proceeded to describe what event took place on those dates, and then I've also put the particulars of which are found in the invoices attached, which make reference to the evidence in support. Now, you'll notice that paragraphs that follow, more often than not, should follow the same format: a date, an event, and the evidence. However, sometimes you won't actually state the date because, in effect, what you're doing is you're importing it from a previous paragraph. So, for instance, in paragraphs 6 and 7, I don't need to state the date because it's obvious from paragraph 5 what the dates are that are relevant. Also, I don't need to state the evidence because, again, that's also imported from paragraph 5. When we get to the personal guarantee, again, you can see I start by stating the date, the event that took place on that date, and you can see I put a copy of which, referring to the personal guarantee, is attached here to bearing the signature of Joseph. Again, the evidence to support that date and the event that took place. In the following paragraphs, again, I don't have to reiterate the date. It's being imported from paragraph 9, as well as the evidence in support is also being imported from paragraph 9. Now let's talk a little bit about the documents that are to be attached to the pleadings. The standard form encourages us to attach any documents upon which we intend to rely to the plaintiff's claim. However, that's not always possible. Sometimes the documents are not available. Sometimes the documents might be quite voluminous. In any event, if we take a look at the Small Claims Court rules, in particular Rule 13.03 sub 2, it deals with the issue of disclosure. And in that rule, it states, at least 14 days before the date of the settlement conference, each party shall serve on the other party and file with the court A copy of any document to be relied on at the trial, including an expert report, not attached to the party's claim or defense, and B, a list of proposed witnesses. Now, although the rules state that documents are supposed to be provided at least 14 days prior to the settlement conference, what is standard procedure is that at the settlement conference, the settlement conference deputy judge will ask whether or not the documents have been exchanged, what documents may still need to be exchanged, and generally there'll be an order made as to the exchange of documents. Perhaps that documents be exchanged by a certain date or a certain number of days before the trial date. Now, one last comment. Always remember, if you don't plead it, you can't rely on it. So make sure that your pleadings contain enough particulars to make out your case, because you may not be allowed to raise other issues that you haven't pled at the trial. All right. So in our next video, we'll take a look at issuing our plaintiff's claim, both electronically and over the counter. And for those of you who are already familiar with these techniques, I'm sorry. It is the next step in the process. We do have to cover it. All right, until then.